morning, everyone. Yeah, that's kind of my question. I will say that aside from this making the news, none of the fallout that I was concerned about seems to have made news. So yeah, I suspect this part of the stream's only gonna go for like 45 minutes or so, maybe even less. Well, no, probably about 45 minutes for Judge Souede to read the rest of the jury instructions. And then, if it's a quick deliberation, then hopefully, right after lunch, they'll come back with the verdict. But the jury gets as long as they feel is necessary to make their deliberations. So when they're done, they're done. I mean, he only has one charge, but fun tidbit about Portland juries. Some reading I did a while back during Prohibition. Um, Apparently, it was not unheard of for jurors to have cases with bootleggers, making illegal alcohol. During deliberations, they would drink the alcohol and then acquit the bootlegger for lack of evidence. Oh, yeah, I totally agree, Melissa. Even with Alan Swinney, which was a lot more charges and a lot more nuance to the case, there was, I think it took them like a total of 3 hours. Ah, yes, jury nullification. The two words that'll always get me out of jury duty, even if my disabilities don't make them excuse me right away, which has happened twice already. As soon as I start yammering about my disabilities, they're like, no, we don't need you. They can never keep timetables straight. They said 3 to 4 minutes, and that was like 9 minutes ago.
The state would prefer I can call this case.
Thank you. Your Honor, we are here in the matter of State v. Lewis, case number 19 CR 53040. I think I got the right case.
I think so too.
All right. This is the time and place for, I believe, the final day of trial. Representing the state of Oregon, Brad Kalbaugh, Kalbaugh. My bar number is 074335. The defendant is present, out of custody, represented by counsel, and Mr. Hughey's present as well.
Mr. Kalbaugh, thank you.
Good morning, Your Honor. Also for the St. Sean Hughey, Hughey, bar number 152776.
Mr. Hughey, good morning. Thank you.
Good morning, Your Honor. Kelly Doyle. I haven't ever spelled my name. Doyle 840394. Attorney for Mr. Mackenzie Lewis.
Mr. Doyle, thank you. Good morning, Mr. Lewis. Good morning to you, sir. We had talked a little bit at the end of yesterday about concerns that one or both parties may have had given the overnight, the reality that we did not finish yesterday and we finished today, and there's been much said in many quarters, is my understanding, about what happened yesterday. If anyone wants to be heard on that or any related issue.
Your Honor, just for the record, the state's concern was that you, in granting Mr. Schultz's motion particularly, had very harsh words for the state, which in our view went above and beyond what was needed to simply make your ruling. Those words were parroted in many different media outlets. I don't know whether any jurors saw those or not. Your Honor instructed the jurors not to watch the news, not to look things up. At this point, rather than bring it up yet again, I think the best course of action is just to make sure everyone's good to go and go forward. I don't think it makes sense to try to ask each individual juror whether they saw anything or not. I don't know if that's fruitful. I think if we ask jurors to just come forward if there's something wrong, I don't know. Maybe we just leave it alone and go forward and remind them that they're only to look at the evidence. I'm not really sure what to do with it at this point.
Fair enough. I think I've heard you identify two different options, which I'd be fine with either. I'm interested in Mr. Doyle's view as well. Option number one is we do nothing and we leave it to the jurors to decide if there's something they want to bring to the court's attention. Alternatively, we could call the jury in. You didn't use these exact words, but it would be something like just saying good morning to the jury and asking. We obviously talked a little bit about at the end of yesterday about news media and that sort of thing. Does anyone have any concerns about anything that has happened since we were last here yesterday that they want to bring up?
I don't know that we can do it.
Yeah, Mr. Hugh and I guess, are in agreement. We probably can just do nothing at this point. And our jury panel, I mean, it's been going on for a week and a half. At one point, we did have a juror reach out and say, hey, I think something happened. So we're going to be optimistic and hope that if there is something that happened, that the juror would reach out, just like other jurors have done in the past. So
Okay.
our preference would be to just, I guess at this point, unless Your Honor has gotten some sort of phone call that we don't know about, to just let things go and probably dismiss the alternate so that we can get started on deliberations as soon as we're done with our closings.
Okay. The court and court staff have not received anything from any juror. I think the state's position is well founded. I think it makes sense. Mr. Doyle, do you have anything? Would you like to be heard on this issue at all?
I was thinking, I'm just, I'm not sure whether people would say one way or the other, especially like sometimes when Mr. McDermott's court sheet comes up, underneath they see, you know, all the different news people that are, you know, and this is newsworthy one way or the other. I'm going to leave that to the court's discretion.
Okay. Thank you, Mr. Doyle. I think I'm inclined to defer to the state's preference, given where we are and how we got here. Again, if court staff or I hear anything, we will let the parties know immediately, and then we can confer and decide how we'd like to proceed. Are there any other matters that we should take up outside the presence of the jury?
There are, Your Honor. Prior to getting started, we had a brief discussion off the record with Mr. Doyle, myself, and just for the record, Mr. Buchel, who's now not a party to this, but just in the gallery. My understanding is that Mr. Doyle intends in his closing to potentially read passages from the Holy Bible and to hold up a cross as a demonstrative. The state would object to these, and rather than bring the jury in, have Mr. Doyle get started, object, and send them out again. We believe that that's completely inappropriate. On this case, it's essentially asking the jury to, instead of simply defer to Your Honor's law and look at the facts, to consider religious beliefs as far as how they should decide this case. There could be situations in which, you know, if there's a trial where the organization on trial, for example, is the Seventh-day Adventist, perhaps there could be more of a religious overtone. But based on this case, the Bible quotes and the cross being waved around for this defendant, there's nothing in the evidence that would support that, short of some affiliation with Patriot Prayer, which, based on pretrial motions that this defendant joined, was largely evidence that wasn't admitted into the record. So we would object to defense trying to make this a case where they're reading from the Bible and holding up religious icons.
Okay, thank you. Mr. Doyle.
Well, I have the Bible here. I can in front of the jury, open it, write down the quote, and close it. It's symbolic speech, obviously. And that's what this case is about. One of the people who will be in the videos is wearing a big cross. And then some of the other people are calling him names, you know, Nazi or whatever. It is a free speech element. There are elements of free speech that have been drilled over and over. What is symbolic speech? What is not symbolic speech? And I don't know if we want to address this matter along with Mr. Hughey's closing argument yesterday on some issues, or if we want to deal with them one at a time.
Well, let's get it all into the pot now, and we might have to tease out issue by issue, and I certainly have follow-up questions about your intended closing, but I'm fine with you. If there are concerns or objections or requests to strike something from Mr. Hughey's closing yesterday, I'd like to hear them now.
I don't know if we can strike it or if a closing argument. Mr. Hughey, he says, you know, hard rubber gloves. Hard knuckle gloves, or his statement, any refer to the gloves would either need a curative instruction, best evidence, because the gloves were not presented to the jury. Any of the things about the gloves and the hat was on the video. And it's very problematic. And of course, the court has said that I cannot, it's not going to instruct the jury that clothing is symbolic speech. But when he said, and no one else that I can recall remembers this, but I heard him say that there's a possibility in the gloves that Mr. Lewis's blood type or something is on there or
I
something.
think that was in a reference to the helmet.
I'll take it to the helmet then too.
Yeah, the big O positive stamp on the helmet.
Yeah, I mean, that's so problematical. Having the helmet and the gloves. I mean, I don't know what the state's view is. My view is that when he changed clothes because of Antifa's reputation, and he did not know, maybe he should have known, that they were going to pepper spray him in the eyes. And there's footage after footage of him writhing in pain. I mean, my theory was if he was going to prepare for battle, he should have brought swimming goggles too. And I can.
All fair for argument.
But I just, when they said that his blood type is on the helmet and the gloves, that they refer to them in different ways, we did not put on glove testimony. I think it's pretty clear to see that they're just sort of like a motorcycle glove, not hard knuckles or brass knuckles, and definitely not the fellow in the fat little guy who has brass knuckles all through the film, scaring the, when they're driving them away, he's with his brass knuckles. So.
Okay, let me work in reverse order, and then I have some questions at the end. With respect to the helmet, we could play it back, but my recollection of what Mr. Hughey said was that the jury is empowered to infer that that O positive decal on the helmet was Mr. Lewis's blood type. I agree with that statement. That is an inference that the jury could. They don't have to, but that's an inference that the jury could make from the helmet. The image of that helmet is in evidence. That's something the jury would be empowered to do with the evidence for the purpose of determining Mr. Lewis's state of mind later, if and when the jury get to the point of having to decide whether or not Mr. Lewis intentionally or recklessly caused grave public alarm. With respect to the gloves, the evidence of the, as you suggest, Mr. Doyle, the evidence of the gloves on the video is the evidence of the gloves we have. The state characterized them as being hard gloves. I don't know that I know exactly what that means. They're not the hardest gloves I've ever seen. They're harder than human flesh. I do not think that the argument went beyond, again, what a permissible inference from the evidence in the record would be. And so I don't think that argument is improper, although certainly you are free to call it out and discuss it and suggest the state is exaggerating if you think that's an appropriate thing to do. Avoiding ad hominem attacks, of course, but suggesting that the argument is an exaggeration. So I think those, so to the extent there's objection to those two, those objections are overruled. With respect to your closing, I have tried to be as consistent as I can, that I do not believe that this is a speech case in the sense that Mr. Lewis may not be convicted based on anything he said or any expressive conduct or symbolic speech. It's an instruction I've given to the jury. It's an instruction I've given to the parties. To the extent that you intend to talk about Mr. Lewis's speech on that same question of his intent, I think that's an avenue that is available to you. That is to say, Mr. Lewis's intent was not to create grave public alarm. Mr. Lewis's intent was instead to engage in this kind of speech. I think that's available to you, not to suggest that his physical conduct was protected as speech, but on what I think is a live issue in this case, which is what Mr. Lewis's state of mind was, at the time that he engaged in physical conduct that the jury might find to be violent and tumultuous. Does that bouncing of the ball, are you tracking those bounces?
I'm objecting to each one, but I'm tracking.
Fair enough, totally fine. And I'll make sure you have a chance to make that record. The question then is what is permissible and what is not permissible. If your argument is Mr. Lewis's intent was to promote some religious belief or religious purpose, or his intent, or to fulfill some religious obligation, I think that is something you can say, because I believe it is relevant on the question of his intent. With that said, there are some limits, that there are confines that you're going to have to keep to. I don't know what the purpose of showing a cross to the jury would be, for example. I don't know how that symbol goes to Mr. Lewis's intent. Likewise, if you plan on quoting a Bible verse, I need to hear what it is, because the question for me will be whether or not it's relevant, that is to say, whether or not it goes to the question of Mr. Lewis's state of mind. If it doesn't, then I'm hard-pressed to see it as a allowable argument, but I'm open to the possibility that it does.
Cover it now.
Sure.
While we're covering that, Your Honor, the state's follow-up objection would be this issue that Mr. Doyle's permitted to argue that Mr. Lewis was there for a religious purpose. Based on the rulings from the court on defense's motions, the history and the basis of what Patriot Prayer is and what's going on there, none of that came into evidence. We're left with a video which doesn't show Mr. Lewis doing anything religious overtly that I can see.
So a very fair,
Those would be facts, not evidence.
a very fair critique. I should have spoken a little more carefully. The question of Mr. Lewis's intent is in this case. There is no evidence as to what his intent was. I agree. Let me hear the verse and then let me give you a ruling.
God is our refuge and strength, a very present help in time of trouble, from Psalms 46:1.
Okay. No. That is not appropriate meat for argument, and I'll deny Mr. Lewis's request to present that.
But the cross was worn by Mr. Gibson.
Who, Your Honor,
And
acquitted.
he was in close proximity. One of the issues for the jury is self-defense or defense of others. I believe it's defense of others. It's kind of the same one. And they're shown together.
Okay. Again, I agree that defense is in the case. And I agree that Mr. Lewis and Mr. Gibson were in close proximity. I do not see how the cross is relevant to that inquiry. And so I'm also going to deny that over Mr. Lewis's objection. What I should have said had I been speaking more carefully, is Mr. Doyle can explore the question of Mr. Lewis's intent. He can offer alternatives to the state's theory of what Mr. Lewis intended. There are sort of an infinite number of alternatives. It's either what the state thinks or it could be anything else. I don't think it's improper for Mr. Doyle to suggest here are some other things it could be, even if those other things happen to be religious.
It is, if it requires the jury to speculate, because Your Honor's already instructed them that they cannot base their deliberations on speculation. So if Mr. Doyle was to say, even though there's no evidence in the record, it could have been any number of things. That's not just argument, that's asking them to speculate, which they're already instructed not to do.
The point though is not that the jury is being invited to say, oh, it was this other alternative, or it was this other alternative, or it was this third alternative, right? In arguing that the intent was not what the state says it was, the defendant is allowed to say it could have been a different intent. And there can be possibilities of examples of other things it could be. Again, the point is not that the jury says, oh, it wasn't with the intent of causing grave public alarm. It was rather a religious driven intent. The point is
which is what I heard Mr. Doyle say he intended to argue.
What Mr. Doyle can essentially present are hypotheticals, other examples of what might have been in Mr. Lewis's head, understanding that nobody was in Mr. Lewis's head. And had I been speaking more carefully, that's what I should have said, is that Mr. Doyle, you can argue that the state has not proved intent. You can argue that there could be a number of other things that Mr. Lewis intended. You can provide examples of those things. What you cannot do is argue affirmatively, Mr. Lewis was acting with religious intent, because Mr. Kalbaugh is right. That evidence is not in the record. Does that, whether or not, I understand you're objecting to the drawing of that line, but is that line clear enough?
So I can leave my Bible, my nuts, and my cross on the table and argue that there's symbolic speech of some sort?
Did you mean the almonds, or?
Yes.
I don't know what the almonds are about.
I need a little more understanding of the way in which you intend to employ the notion of symbolic speech. Obviously, we have the flag issue.
The difference between most attorney war stories and most judges' war stories that people listen to judges. That being said, yesterday I was choking and had to take a point of personal privilege. Those were the reason why I did not realize that I was just, so, no one knew why I was choking and what the cause was. And it was just those nuts.
You're welcome to explain that to the jury.
Thank
you. Okay. Any further ruling that is sought?
No, Your Honor.
Okay. Would the clerk please bring in the jury? We'll stay on the record. Do you have? Members of the jury, welcome back. Thanks for your patience. Good morning. I'm very, very glad to see you all. It is preposterous that we still have all of you. For as long as this trial has gone, in the times that we live, for everyone to stay healthy and well and be able to be in court when we've asked you to be, as each and every one of you have consistently, is remarkable and deeply, deeply appreciated. As I've said before, as you'll hear me say again, I know that does not come without effort, and it's a big deal. So thank you all for that. We're going to pick up this morning right where we left off. When we broke for the day, Mr. Hughey had finished the closing argument on behalf of the state. In a moment, we'll hear from Mr. Doyle for his closing argument on behalf of Mr. Lewis. After that, the state will have a chance to offer some rebuttal argument. After that, I'll give you some final jury instructions. We'll then excuse and thank our alternates, and we will invite the jury back to deliberate. So that's the plan for this morning. With that, Mr. Doyle, you may proceed.
Thank you. I'm just looking for the mic.
Oh, thank you. Thank you, Mr. Doyle. Would you prefer to wear it or just have it sitting on the?
I think I better wear it
Okay.
in case.
All right.
When you're ready, just turn it on using this switch. This switch here.
Good morning, ladies and gentlemen. I vary between mask on and mask off to speak. I think you can hear me now, but that's basically for the recording, not for anything else. Mr. Lewis is not guilty of riot. Now, I could sit down and I would have done my job, because that is the case that we're here today. Unfortunately, all of these things have many meanings. You will be instructed that some things are purely symbolic speech. When Mr. Lewis walked with the flag, you will be told that the flag, even though it was to his back heavy, was just symbolic speech. In fact, that's one reason Mr. Lewis, at the Cider Riot, which is named for the tavern, not because it's a riot, when Mr. Lewis was at this place, he had the flag on, and you will see some tapes with a variety of other things. Sometimes symbolic speech is maybe unintentional, maybe not what it was meant for. I don't always use a cane. I can. And on the bus, sometimes it's helpful. It means I can sit on the side seats and not on the other seats. Some people would say, if I had this cane, it meant that I was ready for some fight. Not really. I'm just ready to protect my knees. That's a symbolic speech. I want to explain something to the jury before I go on. Yesterday, I don't know how many of you noticed that I went dashing out choking. It was because I had a few of these. I have had nuts like this many times. These are almonds, by the way. And someone had given me them because I was, you need an afternoon pickup, and I'd had a few, and I started choking something fierce. So what does this have to do with this case? Because one of the things the state in their closing really emphasized was that when Mr. Lewis was coming from the flag wave that he had been at, that he changed his clothes, that he put on gloves, and none of you have seen those gloves. Neither have I. But they are not hard gloves. They're not brass knuckle gloves. They are just gloves, trying to protect against whatever may happen, if anything's going to happen. Doesn't care. I mean, for all I know, they could have been motorcycle gloves. And the helmet is the same way. I'm allowed now to say things that bothered me in the state's clothes. And what bothered me is that they said that the helmet that he was wearing may have had his blood type on it or some goofy thing, I don't know. It was just a helmet to either protect against either the sun or whatever. There is no evidence as to that, but it's just a helmet. Could have been a motorcycle helmet to go with the motorcycle gloves. This is just an argument. You are limited to what you saw on the film or will see. Not my arguments and not counsel's arguments. There are going to be some areas that the state has really emphasized. And that's going to be the canister, one canister, not canisters, as the state said in their opening. One canister, a tear gas canister that was thrown at Mr. Lewis, thrown in the area. Mr. Lewis, Mr. Gibson was thrown, and he threw it back. Now, he threw it, I bet the state's going to argue the difference between throwing it overhand and throwing it underhand. But the film will show at State's Exhibit 2, starting at 11:40, and I've looked at this more than I would ever want to look at anything, in slow motion, that one canister went and hit the ground long before it hit the people at Cider Riot. And you're also going to see at State's Exhibit 6, 220, the phone where, according to testimony, Mr. Lewis helped Mr. Gibson when the phone, because it's very dangerous to be on the ground, and he had helped Mr. Lewis helped Mr. Gibson up. Now, and I want to remind you what this charge is. It is riot, not argument, not brouhaha, not Donnybrook, not, as the British detective would have known what it is, a row, which is a real argument, but there is riot. And it's going to be specially defined by the court, and the state looked at their elements, and they have to prove each and every element beyond a reasonable doubt. And I'm not going to put, but it's going to be a grave concern of severe physical harm, and that he had to have that intent when he went from the flag wave, which he knew was going to be just pleasant and overhang, to this incident, Donnybrook, at the tavern. And just as a note, all of these occurred outside on the public street, that they were in their place and he was outside, that they spit on him, they bear sprayed him. In fact, you will see footage that Mr. Lewis was in abject pain, walking away, spritzing his eyes. Now, if he had changed for the purposes of being in a riot or causing something, I forgot to bring mine. I'm a swimmer, and I have swimmer's goggles, and they can protect the eyes so that you can be prepared for something like that. He didn't do that at all. He changed his headgear and his hand gear. Now, I am going to embarrass my client without talking to him. If you notice, he's balding a little bit. If you wear a cap, you keep yourself from getting burned. If you wear any other head covering, helmet, or whatever, this also keeps you from getting burned. It keeps you in place, and it's comfortable. Now, symbolic speech being what it is, out of respect, I of course don't wear the hat in the courtroom. Although on the way down on the bus, someone was wearing a hat very similar, as was I, but he put his feet on the side seat where normally I would sit, so I had to sit somewhere else. Lots of things happen when you don't mean them to be, when you're not intending them to be, when you're not intending to be engaged in this. He knew that he was going to go to people that didn't necessarily want to hear what he had to say, and he did stand out. But at no time did he do any physical act that could even be considered close to being part of an altercation, other than and I left something out, and it will come out, is that he pulled down a mask. He wanted to know who was attacking him. He wanted to know what was going on. Now, we stressed over and over and over again that this occurred in 2019. This was pre-pandemic. This was before we all wear masks except at very specific times. Because if I want you to hear me clearly. I know sometimes I have masked and sometimes unmasked. I'm not terribly consistent, but I still get the drift that most of the time we wear a mask. This was pre-mask day. Wearing masks were very unusual. In fact, the person that he unmasked, who later spit on him and did something, in one of the pictures is the same person who is shown mooning the defendant as part of this altercation, this whatever you want to call it. But whatever you want to call it, you could call it a protest. There were discussions, there were arguments, there were heated passions. Someone was even playing a guitar. In the film, you will see that, and some horseplay. And like so many protests, other people behaved badly. But in this country, we don't convict someone of a crime because of what people did when that person is at a protest that was advertised on social media and it was out. And we certainly don't convict someone because other people spit on them, kick them, pepper spray them, and the like. I will just touch base on a little bit of the testimony that is evidence that you can consider, and not argument that you can't consider. That the location of the event was on social media. Heather Clark testified that one of the co-defendants has it phone out line streaming. She testified that there was a fight between the two down the street, was consensual on both sides. A consensual fight is a consensual fight. It's part of a Donnybrook. It's part of, a bad scene. But it is not part of a riot. I have books and some computers at counsel table, and I have to admit that I used a thesaurus to determine what words that we could use for riot. And unfortunately, I came up with a riot of color, a riot of enjoyment, a riot of flowers. I mean, all these really positive, a party, all these positive connotations with riot, which I'm sure is why that former pub, tavern, whatever you want to call it, Cider Riot, named themselves Cider Riot, because there's so many positive connotations. This is not a case about connotations. This is not a case about associations. This is a case where Mr. Lewis is charged with one count of riot. And you have to find the definition of riot. Grave concerns of violent and tumultuous conduct that you have to, and Mr. Hughey had a much better thing on the board. I'm not going to read each and every element because you will have that with you in the jury room. But you have to find that each and every element, piece by piece of that jury instruction, is happened to bring it to riot. And riot, by definition, I mean, I was looking up, you know, I have said so many times other definitions of riot: Donnybrook, fracas, protest, any number of things. Mr. Lewis changed headgear, protect his hair, gloves, in case something should come up. You may see it sometime, you may not, that he was helping to carry a flag for other people. All of these are things that he would need his gloves for. I couldn't think of any reason to express symbolic speech today by wearing my gloves. I just couldn't do it. But there are so many forms of symbolic speech, and that this is definitely a case that has a symbolic speech, or there is another jury instruction that will say exemplar speech. There are two ways to say it, but speech that is not spoken. And that's one part of this case. And the other part of this case is that other people went over the line, way over the line. Mr. Lewis did not go way over the line. Threw back a canister, pulled down a face mask, pushed back someone who had eventually spit and mooned them, and all sorts of other things. And we just don't convict people of riot for that type of behavior. I really have just about run out of things to say. One of the people in the film had brass knuckles on, and you will see him. He's a sort of a squat person, and he has brass knuckles on. And the state, I don't know, is trying to say that because my client put on gloves to protect his hands in case something should go wrong, in case he should fall down, in case there's something there, that is the same as putting on brass knuckles to create a true definition of riot? No, not at all. And I'm making an argument of self-defense, and I'm relying on you to recall what Mr. Gibson said when he was on the stand, that Mr. Lewis had helped and protected him, helped pick up his cell phone for him, because in a situation like this, if you're kneeling or whatever, you are subject to more to hurt. And he is protecting Mr. Gibson. That was what Mr. Lewis was doing. I think I owe you an explanation. Detective Trainer, the gentleman who introduced a lot of the films, had an accent that I did not recognize. And out of the presence of the jury, I asked him where he was from, and he said he was from England. I just wanted to say that one of the definitions that I said before, Donnybrook or row, R-O-W, which mostly is row, but is also pronounced row, is an argument, can involve many, many things, but it is not a riot. I want to make sure I've covered everything and maybe some things 2 and 3 times, because this is my only chance to speak to you. The state has the burden of proving every element, even ones that you'd say, oh, that's a given. But that is not a given. There is no givens in this case. And Mr. Hughey, brought up things about what the helmet could be, what the motorcycle gloves could be. We're not going to speculate. We're not going to guess whether Mr. Lewis rode a motorcycle or was going to ride a motorcycle or whatever. That doesn't matter. But just his gear also does not matter. We did not show what the gloves were. We did not say, if they don't fit, you must acquit, because there were no gloves brought into evidence. There was no helmet, headgear, hat, or whatever brought into evidence. You have to look at the things, look at the films, and decide exactly how those are characterized. And if I wander and you say, oh, Pat Doyle, he's wrong on this, he's wrong on this, he's wrong on this, on that, it's called reasonable doubt. And that's all we have to have on just one of the elements, because this is a very complex definition of riot with many, many moving parts. And you gotta look at each one of those, because it doesn't matter what I say, thank goodness, because I'm assuming the state's going to follow with Mr. Kalbaugh, who, like myself, has a rare disease, is that he enjoys this. And he's going to, he's going to shape the evidence just as much as he can for the state's favor, because that is his job. And he gets 2 shots because that is his job. And we're what can I say? We both like our jobs. And I just want to emphasize that all of those elements, every single one of every single has to be proved beyond a reasonable doubt. That, and if you cannot find that under the strict definition of riot, with all those elements, with the strict instruction, what beyond a reasonable doubt means, that I need to gather my things and say, how I start is how I will end. Ladies and gentlemen, Lewis is not guilty of the crime of riot. Thank you.
Thank you, Mr. Doyle.
I have some instructions on the gas canister and that on where to see some of these
Shall
Objection, Your Honor.
I'm sorry.
We
I'm sorry.
discuss- I don't know what's going on. We should discuss that.
Okay, yep. Folks, we're going to take a 1 minute break. You're welcome to stand and stretch in place. We'll go off the record. Why don't we see the lawyers in the back? Members of the jury, Mr. Doyle has asked for permission just to point you to one part of the video evidence in this case. I'm going to let him do that, and then I'm going to explain something about that. Mr. Doyle.
Yes, one is State's Exhibit 2 at about 11:40, and you will need to run that exhibit at half speed or less to be able to see where that gas canister ended up, and that it didn't end up in the I'm going to call it scrum, but it's probably not into the Antifa group. And then State's Exhibit 6 at 2:20 is where the phone is for the defense of someone or defense of others. And the court will instruct you on how to review all that evidence. Thank you.
Thank you, Mr. Doyle. Before we hear rebuttal argument, I'm just going to follow up with the jury. This is something I was going to tell you at the very end. I'll tell you now. I'll probably tell you again at the very end. The jury, while it's deliberating, will have access to all of the video evidence in this case. There'll be a laptop provided. The clerk will show you where the files are. If the jury wishes to take Mr. Doyle up on his offer to play some portion of the video at a lower than full speed, and if the jury doesn't know how to do that, again, your reference point is the clerk who can show you how to do that. So that's why Mr. Doyle was pointing you to particular times in the video, is because you'll have access to the video while you're deliberating. With that, we'll turn to rebuttal argument. Mr. Kalbaugh.
Thank you, Judge. If I could have a moment to mic up.
Certainly. I think it is off, so miking up and I think also turning on.
Can you hear me?
You're caught. Thank you.
All right. I don't enjoy this. We had to spend an entire day yesterday watching a whole lot of people doing a whole lot of horrible things. Whether Mr. Doyle spent a lot of time talking to you about what do you call that? What do you call this group of people? We can call it, a row. You can call it, Joey Gibson called it a riot. We can call it tomfoolery, horseplay, whatever you want to call it. What matters is what the judge instructs you constitutes riot. So you got people doing stuff, but we're not here about everyone doing all these horrible things. We're here about the defendant's conduct on May 1st, 2019. And whether you think that sure looks like a riot, is this a bigger riot, is it tomfoolery, whatever you may want to look at that as, what you have to do next is look at the instructions that the judge has given you to say, hey, I don't care what you want to call it generally, but if you want to find this person, decide what they did, here's what you have to consider to get there. Here's your roadmap. Mr. Hughey spent a lot of time yesterday with you at the end of the day going through that roadmap and how that law, how those elements of the crime match up with the facts. Here, we have the defendant arriving a couple blocks away with some sort of ragtag mob that's armed. You have states 4A and 4B that show the defendant suiting up. And I'm saying the defendant because you see a lot of other people doing a lot of things. I just said that, but we're here right now about the defendant and what he did. You see him suiting up with these gloves. Mr. Doyle wants to characterize them as just gloves you would have in your dress or whatever, however you want to look at motorcycle gloves. You're allowed to use your common sense and reason. You have the same video back there in deliberations that we've been playing. You're allowed to look at that video, look at states 4A and 4B, look at those gloves. You can decide for yourselves, are those the gloves that I have in my drawer for when it's cold out? Or are they something else? Are they closer to what Mr. Hughey characterized them as? You decide that. The lawyers are arguing. You look at the facts and you decide that. The helmet. Mr. Doyle characterized the helmet as something you wear to keep the sun off your head. You get to use your common sense, look at the video. You don't have to hold the helmet in your hand, but you don't have that. Mr. Doyle's right, we haven't given that to you. You don't have that evidence. But you can see it on the video, and you can use your common sense to say, is this something that someone's wearing to keep the sun off his head, or is he suiting up for battle? You can watch the video and watch the defendant march with this ragtag group and their weapons over to where these people, these Antifa folks, people dressed in this black garb with these masks, are drinking, essentially minding their own business. You can watch the video where the defendant goes up to them, and you can watch the conduct. You can watch all the conduct if you want. You've seen it all. We've played it for you hour after hour. The conduct we're asking you to focus on is this defendant's specific conduct. Mr. Hughey, would you please play the video? Oh, Court, could I please have access to the screen? Sorry. Mr. Doyle described this issue with the canister as rolling it right back. It hit the ground. You can see it. Well, let's just play it. You have the video. It's a couple seconds long. Mr. Hughey's going to play it for you. We don't need the audio. Just turn the audio. We don't need the audio. I don't know what's going on. Get the video queued up there to 11. I think it's 11:40. You have the timestamp on there. I'll give it to you, Mr. Hughey. We're good. You got it? 11:45 or 11:43, right around there. You're 11:17.
Objection, that's blocking.
Yeah, I don't want it up there either. Can you pause that? You got it yet? Okay, here we go. I guess we're going to have the video. I don't care about the video or the audio. Listen, let's look at the video. Watch him throw it. There it is. Stop.
I'm sorry, Mr. Kalbaugh, I just need to interrupt. Mr. Doyle, was there an objection, or are we past it?
Well, we would object to, the state saying that he was marching. We would object to the state on the sound, not having the sound, because they can have all of the sound to see where the pepper spray, they had emptied the pepper spray onto,
Okay,
and then he lobbed it back.
okay. Mr.
And
Kalbaugh,
that was the one that we wanted in slow motion so that they could see that the canister landed safely in front of the group and not at the group.
okay, Mr. Doyle. Does the exhibit that's going back with the jury have the sound or not have the sound?
The exhibit that's going back with the jury has the sound.
Okay.
For purposes of my rebuttal, I just wanted to play 10 seconds. I got 25 seconds or 30, and I got a VLC media player help screen that I didn't want.
Okay. On that basis, on that record, the objection's overruled. Mr. Kalbaugh, you may resume.
Thank you, Judge. You saw the video. When you're watching it, you could listen to the audio again if you want. If you find that it's painful because you watched it and people yelling and screaming at each other gets convoluted, focus on his actions. Mute it if you want to. You have the evidence, do what you will with it. Turn it down if you want. But look at the clip that I just played or that Mr. Hughey just played. Hopefully you won't get a help screen or anything. Look at the clip. Watch what the defendant does. Before that, you'll see another spot where we've already discussed it. You'll see him strike a woman in the face. Look at that. Look at the judge's instructions on the definition of violent and tumultuous conduct. Read it. Read what the judge gave to you. He read it to you once. He'll probably, I don't know if he's going to read it to you again, but you have it. You'll have this in writing. Refer to it. Discuss it amongst yourselves, and you will find that that's exactly what he did. The suggestion that it's somehow justified by self-defense, it's not. That's as preposterous as the idea that he's wearing the helmet to protect his head from the sun. It's not justified by self-defense because he's the initial aggressor, and also because there's no threat at the time he does it. The idea that he had to strike this woman in the face because she had just done something and knocked the phone out.
Objection, sidebar.
We're going to take a quick break. I'll ask you to stand and stretch in place if you wish to, but stay where you are is the important part. We'll go off the record. I'll see the lawyers in the back for a moment. Defendant's objection is overruled. Mr. Kalbaugh, you may resume.
Thank you, Your Honor. All right. Mr. Hughey, oh, they have the video. State's Exhibit 2, the timestamps you want. Mr. Doyle was giving you some. I'll give you some more. If you look at, it's early in the video. Within the first couple seconds, you see them all arriving, and then you see it 2:29 through 2:39. Would you actually bring that one up? Pause. When you watch that back in deliberations, you can do it with the audio on, with the audio off, up to you. What you see in this clip is you do see someone doing something. You shouldn't spit on people. That's not okay, okay? But what you see her do is you see her get the defendant yank her mask down after Mr. Gibson's holding her back. It's like a schoolyard taunting thing where he's holding her back as she's yelling and screaming. You see the defendant yank her mask down. You then see her react and start spitting at both people. You then see her knock the phone out of Mr. Gibson's hands, and you can see it. I'm arguing what you see because when the defendant decides after the phone's been knocked down, he doesn't step in front to protect Mr. Gibson. He strikes her in the face. That's not self-defense. The threat was over at that point. That's revenge. That's no different than two kids in a schoolyard where one hits the other one and the other one says, oh, you hit me, I'm gonna hit you back harder. It's revenge. It's not okay. It's not justified. And it's especially not justified when you showed up with an armed mob to precipitate the whole thing. Look at the video, read the judge's instructions, follow the law, consider the arguments of everyone. Don't convict the defendant based on his speech. Convict him for what he did. Don't decide, oh, well, there's a lot of people doing bad things. We should convict him for that. No, convict him for what he did, not for what other people did. Look at the evidence. You'll find that the state's proven its case beyond a reasonable doubt. Thank you.
Mr. Kalbaugh, I'll remind you of the microphone.
Thank you.
That's fine. Members of the jury, it is solely your responsibility to make all of the decisions about the facts in this case. You must evaluate the evidence to determine how reliable or how believable that evidence is. When you make your decisions about the facts, you must then apply the legal rules to those facts and reach your verdict. Remember, however, that your power to reach a verdict is not arbitrary. When I tell you what the law is on a particular subject, or tell you how to evaluate certain evidence, you must follow these instructions. Do not allow anything I have said or done during the course of this trial to suggest that I have formed any opinion about this case. Keep in mind that a judge is required by law to give certain instructions in every criminal case. When I have sustained objections to evidence or have ordered that evidence be stricken or excluded from your consideration, you must follow those rulings. Do not consider such matters during your deliberations. Base your verdict on the evidence and on these instructions. The lawyer's statements and arguments are not evidence. If your recollection of the evidence is different from the lawyer's recollection, you must rely on your own memory. In deciding this case, you are to consider all of the evidence that you find worthy of belief. It is your duty to weigh the evidence calmly and dispassionately and to decide this case on its merits. Do not allow bias, sympathy, or prejudice any place in your deliberations. Do not decide this case on guesswork, conjecture, or speculation. Do not consider what sentence might be imposed by the court if the defendant is found guilty. Generally, the testimony of any witness whom you believe is sufficient to prove any fact in dispute. You are not simply to count the witnesses, but you are to weigh the evidence. Keep in mind that each party is entitled to the considered decision of each juror. Therefore, you should not give undue weight to another juror's notes or memory if they conflict with your recollection of the evidence. The court has provided written instructions for your use. When you use these instructions, do not place undue emphasis on any particular instruction, but rather view these instructions as a whole. When you return to the jury room, select one of your members to act as presiding juror. The presiding juror has no greater voting weight, but is to preside over your deliberations and to be the spokesperson for the jury. You should then deliberate and find your verdict. If it becomes necessary during your deliberations to communicate with me, do so in writing. I will consult with the parties before responding. Here's the way that procedure is going to work. If anyone has a question or otherwise wants to communicate with me, whoever wants to can write that question or that other piece of information down on a note. The presiding juror will sign the note. You'll then contact the clerk. He will tell you how to do that. He will take the note. I need to talk to everybody before I respond. Most likely, you will get a response from me back in writing. It may take a little while to do the work on this side. I would encourage you, if you can, to keep deliberating and doing the other work you need to do while you're waiting to hear back from me. If that's not possible, if you're sort of at a sticking point and you need to wait back, please know I'll get back to you as soon as I can. It will almost certainly, as I say, be in a written note back to you. No one except for the jurors is to be involved in your deliberations. Therefore, do not tell anyone, including me, how many of you are voting not guilty or guilty until you've reached a lawful verdict or have been discharged. Guilty verdicts must be unanimous, which means that each and every juror must agree on a guilty verdict. But not guilty verdicts may be non-unanimous. At least 10 jurors must agree on a not guilty verdict. If you are divided 9-3, for example, you do not have a not guilty verdict. When you have arrived at a verdict, the presiding juror will complete and sign the appropriate verdict form. And as with everything we're doing in this case, the presiding juror will sign using the presiding juror's number instead of the presiding juror's name. After you've reached your verdict, you'll signal the clerk, and court will then reconvene to receive your verdict. When you are deciding your verdict in this case, you're going to use the verdict form that we're providing for you. I told you about the jury instructions notebook. In the back flap of that notebook is our verdict form. I'll read it for you now. It says, "We, the jury, do find our verdict upon the counts committed to the jury as follows. Count 1, riot. There's a space for not guilty. There's a space for guilty. There's a line for the date. And there's a line for the presiding juror to sign his or her juror number." A couple of additional housekeeping matters. While the jury is in deliberations, you need to stay in the suite, of course, but also all electronic devices have to be turned off while you're deliberating, not simply in silent mode, not on mute, but truly off. If you need to communicate with someone, if you need to check a text message or an email if something important is happening, simply ask the clerk for a break. He'll put the jury on a break, and folks can use their electronic devices to communicate with whoever you need to. Likewise, if for whatever reason you just have to get out of that space for a minute, you can ask the clerk for a break. He'll give you a break. When everyone comes back, you'll let the clerk know. He'll take you off of your break, and you'll resume deliberations. What is implied there, but what I want to make explicit, is a partial group of the jury cannot deliberate. If you're on a break and people are wandering around and there's 4 of you sitting around who want to keep working, don't. Wait until everybody is back. You are formally, the break is formally ended, and at that point you can resume deliberations. Does that make sense? Okay. As I mentioned a few minutes ago, but just to be clear, you will have a laptop in the jury room that will have all of the videos that are in evidence available to you. If you have any trouble, you'll get some instruction on how to operate the equipment. If at any point you have any trouble or you want to play something in slow motion or that kind of thing, let the clerk know, and the clerk can help you with that. Does that all make sense? Okay. It's time to excuse our alternates. I am astounded and really pleased and grateful that we have everybody here at the end of this trial that we had at the beginning of this trial. Alternate jurors occasionally feel different ways upon being discharged, sometimes relief, sometimes frustration. There's a full gamut available to you. I won't tell you how to feel. What I will tell you is how I feel, which is deeply grateful and appreciative for the work of the alternate jurors in this case. When I identify you as an alternate, you can go back to the jury room. Don't tell anybody what you think about the case. Collect any belongings, and you're then free to go. Do not, however, think that you are fully off the hook. All of my instructions to you about continuing to not do any research and to not talk to anyone about this case is going to continue until we have a verdict in this case. That's because if something goes wrong, we may need to call you back into service. So you're still going to operate under those instructions. We will reach out. We will let you know as soon as as soon as you're discharged fully and those instructions go away, and you can talk to who you want and do whatever research you want. Does that all make sense? Okay, as a reminder, our alternate jurors were selected, the seats were selected before we knew who any of you were. So this is the opposite of personal. Juror number 9, juror number 93, I'm very grateful to you both. You are alternate jurors. Thank you for your work and your diligence. You can step out with the rest of the jury in a few minutes. You don't have to go right this second. You can keep your notes if you want to. But otherwise, once you're back to the jury room, feel free to say goodbyes, and thank you very much for your work in this case. If you need a letter, let the clerk know, and we'll get you a letter confirming that you were here. Would the clerk and Ms. Henderson please step into the well of the court to be sworn? If you would each raise your right hand. Do each of you solemnly swear or affirm that you will take charge of this jury and keep them together until they've reached their verdict? That you will not, unless by order of this court, allow any communication to be made to the jury, except to ask them if they've agreed on a verdict? That you will not communicate to anyone the state of their deliberations or the verdict agreed on, and that you perform these duties to the utmost of your ability?
I will.
I so affirm.
Thank you very much. Would the clerk please take charge of the jury and bring them back to the jury room? Members of the jury, good luck in your deliberations. We look forward to seeing you back here soon. Thank you. Please bring your notebooks with you. We're on the record. We're outside the presence of the jury. Any exceptions to jury instructions from the state?
None, Your Honor.
Thank you. Any exceptions from Mr. Lewis?
Yes. We're still at best evidence. And, you know, whether it was a SAP or whatever, that was not as important to the case. But when the state says, you'll know what the hat is, you'll know what the gloves is, no, they won't. There's no way to tell from the video exactly whether those are motorcycle gloves or a motorcycle helmet or whatever. There is no way in creation to make the differences that the states wants. And either that would have to be a curative or even a curative that the hat and clothes are symbolic speech. I can live with one of those, but I strongly object to just letting them go and looking at the thing, especially with Mr. Kalbaugh's very able, you know, and I tried to object as much as I could, but I probably over-objected. But with those characterizations, you know, that it wasn't just to protect his, there's no way the jury can tell from that video or from them when they're playing it slow-mo what the garb was entitled to. You know, and whether they're going to play where the tear gas hit his eyes or not. But the state made a big deal about the house. I shouldn't do that. I can't see you. The state made a big deal about that and hammered it with especially the helmet, you know, that his hat had his blood type or some sort of thing. That unless, you know, that's just going to go right by the jury.
Thank you, Mr. Doyle. The exception is received. Mr. Kalbaugh.
I just had a matter for the record before we were done.
Please.
Your Honor, counsel objected twice during my 10 or 15-minute rebuttal argument. Those are speaking objections. They seem to be based on argument, which is the whole point of what I was doing. And I asked Your Honor at the second one if Your Honor would admonish the counsel in the presence of the jury, because I felt that it was detrimental to the state's case, and I believe Your Honor chose not to do so. I was listening. I don't think we did.
Mr. Kalbaugh, we had a misunderstanding. I did not understand that the admonishment that you sought was in front of the jury.
It was.
Okay, I heard you ask for an admonishment. I did it outside the presence of the jury. I did not understand you were asking me to do it in front of the jury. So I acknowledge that, or I agree with the state of the record, which is that I did not do it.
Yes, the state, I guess if that communication was unclear, I guess that's on me, but the state's point of view is.
That's not true. It takes two.
It wouldn't help much to do it out of the presence of the jury, because the whole point of, as Mr. Doyle just said, he was objecting more than he should have, and it seems like it was intentional, especially since yesterday he did point out that he never objects during closing arguments.
Just to be clear, the purpose that I thought the state was trying to pursue in what I thought was a request to do it off the record was to prevent it from happening again, which is what.
Two purposes.
Understood, and I only caught the one. I disagree that that's necessarily the state's fault. Anything else for the record?
No.
Okay. We'll go off the record.
We are off the record.
Okay, so I'm gonna wait a minute to see if something happens that they need to come back on the record. But absent that, we're gonna go ahead and shut down the stream here in a minute or two for the duration of the deliberations. I'm gonna reach out to the court clerk and hopefully get an email when they have reached a decision as to when they have a verdict to read, and when we're going to go back on the record, and then set up the live stream then. But again, I'm going to give it a minute just in case, because there was that whole thing that they wanted that admonishment in front of the jury. It sounds like they're not getting it, and just making sure of that. This was certainly an interesting well, and if it's self-defense, then that is a defense that can be raised. Yeah, and at this point, since I think if they were going to come back on the record, they would have done it already, I'm going to go ahead and shut down the stream. It's for people who tuned in. I know this was a short session today, but we might get a verdict reached before lunch, and if so, then hopefully like right after lunch they would come back on the record to read it. But if not, you know, just keep an eye on our Facebook page, YouTube, Twitch, or Twitter, and when we have something new, we will let y'all know and get the stream back up and running again. In the meantime, be good. Take care of each other. See you later.